On this episode of That Kingsville Podcast, Sebastian Schmoranz is here from McGregor, Sims, Schmoranz, and Hart Law offices in Kingsville. We are going to talk about something that nobody ever thinks about unless it's too late, estate planning and many other things on this episode of That Kingsville Podcast. This episode of That Kingsville Podcast proudly brought to you by McGregor, Sims, Schmoranz, and Hart Law office in Kingsville. So again, for those that watch the episode, I've been using ChatGPT to do the reads for the sponsors and supporters. So you get one this time. So
I feel very honored.
Life throws curveballs. Divorce, surprise will, neighbor built a fence on your lawn. Yep, we've seen it all. At McGregor, Sims, Schmoranz, and Hart, we untangle the legal mess so you don't have to Google, what is a tort?
What is it? I actually don't know.
I don't know.
Usually got a retort.
Oh man. Isn't that like some kind of like, couldn't you have like a beef tort?
A retort?
You're thinking about tarts.
Yes.
Or you're thinking about tourtière, which is a Quebec delicacy.
Or a tortilla, which is coming up with Cinco de Mayo.
There we go.
We handle the serious stuff with a sense of humor, but we're dead serious about getting results. McGregor, Sims, Schmoranz, and Hart, a law office with a long name and the short answer. We've got you. Call us before your next legal oops. We're here to help. Whether it's family law, real estate, business matters, or estate planning, our experienced team is committed to guiding you through with clarity, compassion, and the results that matter. We're more than just lawyers. We're partners in navigating life's challenges. You should probably use ChatGPT to do this.
Are they your new unofficial sponsor of the
I guess. What are we doing here?
I like the dead serious about Will's part.
Yeah.
There's some good lines in there.
That jumped out at me too.
Yeah.
It's witty.
It's a lot better than I thought it was going to be honest.
Thanks, MSSH, for sponsoring this episode of That Kingsville Podcast. Welcome to That Kingsville Podcast. It's me, Kevin, Steve. Special guest this episode, Sebastian from MSSH Law Office in Kingsville. Hey, Sebastian, thanks for coming back.
Thanks for having me.
We've had a couple episodes where you've provided some insight into some town-related things. We're still seeing some of the side effects and the impacts of what those are, but that was kind of like town-specific, in the greater Kingsville. But there's a lot of things that happen in a person's day-to-day life that you guys handle at the office that nobody really talks about. And honestly, until I had kids, I never considered anything about legal things, right? Like, last thing on your mind, like estate planning, wills, trusts. Like, lawyers are for suing guys who like ran into your car, or like, that's what lawyers are for. So, but you've mentioned that recently there's been a kind of an influx of inquiry about estate planning and wills and powers of attorney and whatnot. So that's why you're here today.
Yeah, exactly. It's kind of interesting as the boomer generation starts properly entering into retirement, and considering that they're one of the biggest proportions of our population right now in Canada, we've been noticing that we've been getting a lot more phone calls about estate planning questions. So, making a will, making power of attorney documents, ensuring that all of our, bank accounts and housing related issues are dealt with, starting to think about things like, am I going to downsize? Am I going to age at home? How do I deal with aging children? How do I deal with grandchildren? And how do I ensure that I leave behind a legacy? So a lot of those things have been popping up more recently as we start finding that the boomers are moving towards retirement.
So just for clarity, for all the audience, remember, we're not the news. This is not official legal advice. This is just a conversation about things that, you've been seeing in the industry and people have been discussing, and felt that maybe there is a greater audience of people that have these kind of questions that don't have any insight or direction that maybe we should have the conversation about, because, as we all have children here, families planning, making sure things are set the way when, the unpredictable happens is kind of very important these days.
Exactly. And it's actually led to the point where I used to offer info sessions to the public back when I started practicing in Kingsville in 2016, 2017. And they were never really that popular. Not that many people were interested. And this year I got asked to run one in Harrow, because we have an office in Harrow as well. We have the Golden Law office in Harrow. And for the first time in a long time, we had over 70 people show up, and there were tons of questions, and the session went for almost 3 hours one night at the Harrow Arena. And as a result of that, we thought, well, there clearly must be a need for this. So we've decided that we're going to hold another event on May 6th in Kingsville at Vern's. where we'll also offer some light refreshment. There's no cost of admission. And we'll have some local banking advisors and financial advisors and insurance advisors from Libro Kingsville there as well. But primarily, it's just because we've noticed there have been way more people asking about it than I've had in years past. So I thought it might be a nice time to come on the show and talk about answering some basic questions associated with it.
Yeah, and there's a lot of how do you start the conversation, right? Like, I don't know. Did you guys get wills? Have you got wills yet?
Yeah.
And for various amounts of reasons that, personally you had an event or some insight into why to get a will, right? Like mine was my children and, dealing with an estate from a parent that wasn't prepared. So, having learned a little bit of the hard way, there's things that could have been put in place that would have alleviated a lot of heartache, a lot of unknown kind of steps. But, first and foremost, why do I need a lawyer for a will? Like I Google it I'm going to chat GPT my will. Should I do that? Oh my God, I'm going to do
By
that.
the end of the episode, we're going to chat GPT well. So it actually leads to a really interesting point. But I'll start out with what's really unique around this table is that everybody sitting at this table has a will because statistically speaking, studies suggest that between 50 and 70% of Canadians do not have a will or power of attorney documents of any kind. And the number could actually be higher because people tend to be embarrassed to admit it when they're asked it on surveys. Just like, do you always brush your teeth at night or do you always drive the speed limit? So what we found is there are tons and tons of people out there who don't have them, but it's either an uncomfortable conversation to have because we don't like to think about death, or we just keep putting it off because it seems like one of those boring, grown-up life decisions that nobody really wants to make, just like everybody procrastinates coming up to tax day or, things like that. Why do we typically use lawyers to make wills? A will is essentially a legal contract, and it's a legal contract that says that when I pass away, I want certain things to happen. So the reason why you go to a lawyer is because lawyers tend to be experts at drafting contracts, and that's essentially what a will does.
But I don't know. What were some of the important things that you found, dealing with? Okay, when I'm going through this will process, these are the things that I want to make sure that I've got rock solid.
Well, for us, it was a little more complex because we have like a corporate, actually a couple corporations that are partially owned through family. So it was when we bought the business, then we realized that that a will was going to be necessary because it's dispersing of that if anything ever happened would be a nightmare. But you don't need to have complex situations to need a will, right?
Well, yeah. So essentially, the layman's way of explaining it is a will is an instruction manual for what to do with your stuff after you're dead, right? So
listen, I'm going to leave all my CD collection to Steve because he has an appreciation for some of the bands that I like. So you want my stereo? You can have my stereo.
There we go.
No, it's more complex.
But then I have to come over to play the CD.
See, that's how you keep being
shared.
friends.
That's right.
We'll need a shared custody arrangement.
Yeah.
That's how we remember Dave.
Contractually obligated.
I want the Smashing Pumpkin CD next Friday.
But yeah, I mean, the basics are actually really just that simple. It's essentially to make a will, you have to be over the age of 18 and you have to be of sound mind. And then a will more or less just requires you to name two main types of people and make one very simple decision. So the two types of people you have to name is you have to name your executor, which is also known as an estate trustee. That's the person who carries out the instructions in your will. And then you got to name beneficiaries, and the beneficiaries are just the people who are going to inherit stuff under your will. Those are really the two types of people you have to name. And then it's just a question of either as complex as you'd like or as simple as you'd like to provide instructions as to who gets what and when. And that's the basics.
So if it's that easy, then why can't I do it?
Yeah, like I got a legal pad at home. I'll get the yellow paper, right? Yeah. That's legal, right?
Yes. Oh, if it's the long form yellow paper, it's absolutely legal.
And in transparency, when I chat GPT'd it, it was like, tell me who you want to give me your stuff to. What's your stuff? Any other wishes? Bam. So why can't I just do that? Because ChatGPT, why am I putting on the voice?
I don't think we need it.
I didn't know ChatGPT was from New Jersey.
Yeah, not sure.
I didn't know it was headquartered in New Jersey.
It is,
All right.
apparently.
Yeah, it's run by the mafia. So
Maybe.
it's a common misconception a lot of people have is, can I just download this thing off the internet? Can I just draft this thing myself? I know Chapters sells will kits and stuff like that. The main reason is the best way of explaining it is whenever you're dealing with managing someone's estate, you always have to remember that your best witness is dead, right? The will was drafted by someone. They're now dead. That's why we're here. So if we don't understand something in that document, we can't ask the author anymore unless you conduct a seance or something, right? Which that's next week's episode.
Right. Yeah. Seances.
Seances.
Fine, you know.
But so really the basics are the mistakes we see are certain things. So sometimes people think, well, I'm going to save money. I'm just going to do this thing at home. And they draft this document themselves. And they forget that, generally speaking, in order to be legally binding, a will has to be signed in the presence of two witnesses. Sometimes they forget that. Or it needs to be signed in the presence of two witnesses who aren't named in your will. So if your will says, I leave everything to my kids, and then one of your kids is the witness on that will, that could potentially invalidate it. Or, which is the most common mistake, is there are certain key constructions of phrases that need to appear in a will in order for it to be valid. And some of the basic ones on that front are, for example, you appoint this executor. Your executor is in charge of dealing with all your stuff. But if you don't put a clause in that says, and I leave everything I have to my executor, then you end up with an executor that has no property to administer. So there's certain kind of easy pitfalls that people fall into in terms of how they structure these things. Or they sometimes make really vague instructions. And I see this a lot too. And I get that it comes from a good place, but sometimes you see, I leave everything to my son, Bill, and Bill knows what to do. And you sometimes see that in a document, which again is a beautiful sentiment, but doesn't provide any clarity at all about what Bill is supposed to do with the stuff. And arguably it means Bill could keep everything for himself. And if there's other kids or siblings or grandkids that were supposed to leave something, then that's kind of all thrown by the wayside.
I think for us with our wills, it wasn't as much about assets and where it was going to go. It was much about who's responsible for raising the kids and who is power of attorney. So I'm wondering if you can sort of explain power of attorney.
Yeah, so the raising kids is interesting. So when I do will intakes for clients who still have children under the age of 18, we add in a third person in your will, and that third person is called a guardian, because if both you and your spouse die, we'd want to leave some guidance behind in the will as to who we think would be good to take care of those children until they turn 18. Now, a lot of people think, if I name this guardian, does it mean that they for sure are going to become the guardian of my children? No, that's still a decision made by a judge in family court, but they will look to the will to see, what did Mr. and Mrs. So-and-so think about this person when making that decision. In terms of power of attorney documents, so power of attorney documents arguably are even more important than wills. And the reason I say that is because the power of attorney document will apply to you while you are still alive. And a power of attorney document comes in two flavors. There's one for financial decisions and there's one for medical decisions. And it allows someone to make financial or medical decisions for you while you are alive. So if you are incapacitated by reason of stroke or injury or illness or dementia, or if you end up spending long periods of time outside of the country, maybe you're a snowbird and you vacation in Mexico for 6 months of the year and you want someone to be able to make financial decisions for you while you're gone, a power of attorney document would allow you to manage things like that. On the business side of things, you can also make specialized power of attorney documents for companies where, for example, let's say you run a local produce stand and you want to ensure a market.
And more. All your needs at Lee and Maria's. Open now.
He didn't shamelessly throw the name in earlier. I was waiting for it.
Get your tires rotated, get your oil changed, buy some carrots.
Hey, we'll do it all.
We do it and more. It's the more. The point being, so let's say you run an and more kind of business, and you want to make sure that if you get sick, that there is a key person who can make sure the lights get turned on every day and deal with the bills and make sure payroll gets done. That might not be your spouse because maybe your spouse doesn't work with you or isn't involved in the business. You can make specialized power of attorney documents for a business as a business owner to ensure that if something does happen to you, the business keeps operating.
So, all right. getting away from all the explanatory things, let's have a little, personal account of somebody thought they knew what they were doing with what we've discussed so far, like didn't assign a power of attorney, hand wrote it on the back of a McDonald's napkin, but used it after their Egg McMuffin slopped all over and expected you to be able to, like, what's some real life cases without, getting too sensitive in personal detail.
No, of course. So the big issue, the two biggest issues I see is primarily is the classic, well, I'm just not going to do one. So I do run into it pretty frequently that we do have to do deathbed visits or hospital visits where, there is an urgent medical situation such that we want to make sure they have a power of attorney document in place. I'm having triple bypass surgery and it's happening on Thursday. And they call me on Tuesday and say, hey, by the way, I never got around to making a will or power of attorney documents. And if your viewers and listeners take nothing home other than this, is I can typically meet with you and get will and power of attorney instructions in 15 minutes or less, unless your life is really complicated, and most people's lives aren't. And usually our turnaround time is about a week. So it's not like this is some giant involved, awful process that you have to slog your way through and you have to bring me every, pay stub you've ever had in the history of time and your marriage license and your birth certificate. None of that's necessary, right? So thing one, don't leave it till the end, because then we're really rushing. And then if we make a mistake, or if we, think someone might be good making decisions for you, but we were under duress or we were stressed or we wanted to make a decision quickly and we later on regret it, there's not much we can do at that point. The other classic one that we deal with all the time is people thinking, well, I don't need one of these because, the law is just going to explain like who gets my stuff because I just want everything to go to my wife and kids anyway, which is fine, except for the fact that, we live in a country now where more than 50% of marriages end in divorce, but a lot of people don't actually get divorced. A lot of people just get separated and they're still legally married to someone throughout the rest of their life. A lot of people get separated and will never remarry and might never even bother applying to get divorced. So let's say you do get separated and you end up partnering up with someone else for the rest of your life and you live a nice long life and then you pass away. Did you want your first legally married wife to be the one that inherits everything? Or did you maybe want the person who you spent the last 30 years of your life with to receive something? Well, that person has a legal title. They're still your legally married wife, even though you might be separated. So those are the types of situations where we really want to make sure that if there is a major life change, i.e. we get divorced or we get separated, that we want to remake these documents so that it's clear who are the decision makers, who is going to inherit something. And then the other big one we miss all the time is lots of people have children with disabilities. And there are mechanisms by which we can make sure that their inheritance doesn't negatively impact their government support. So one of the big issues we have, and I don't know why the government treats it this way, but let's say you receive ODSP or you receive, CPP disability money. If you receive an inheritance, the government views that as income and they cut off all your government support funding, which is unfortunate. Now, had you met with a lawyer, we could have drafted your will in such a way that your disabled child's inheritance would be paid to them in a way that wouldn't negatively impact their government support. And so these are things where, again, if we don't think about it in advance, it's going to cause us problems down the line.
So what happens in like a situation where maybe I forgot that I did a will because it was so long ago and, it was filed away and you know what? I did get remarried and I create another will that's contradictory. How does that work?
So generally speaking, we always want to go with the will that has the most recent date, right? Now, this is again where we run into problems because what if we can't find that document? Then we go with the one that we can find, right? And this leads into a conversation about, okay, so when we die and we have this will, assuming we did it right, there's this big scary word that everybody talks about called probate. And it's where I get a lot of my panic phone calls from a lot of my older clients because they think it's going to be this long, horrific, drawn-out process. Because if we've watched enough episodes of Matlock, we always assume that
lawyer on the TV, I gotta go to trial.
We assume a probate dispute could take 10 years. It's not going to. And it generally speaking involves us filing paperwork on your behalf with the court, and it's usually resolved within 6 months. But problem is, we now can't find that will, or if we find a much older will, now we're sitting there going, well, is this really what this person wanted or not? And once again, your best witness is dead. So I can't ask anyone and say, well, who did you really want to leave everything to, right?
It's kind of like housekeeping, right? Making sure that, the sheets are washed and put away and folded and the dishes are done, but for your personal life and health and well-being. So like when it comes into the possession end of things, like dealing with the minutia to the major, houses, et cetera, how does that help navigate that dispersion and control?
So really the most important thing, either, in a power of attorney for property, which is the person who can make financial and property related decisions for you while you're still alive, and the executor you end up naming in your will, it's really important to pick someone who you think can make good decisions. So sometimes we feel pulled to pick someone who we are married to or who we love or who is our child or who is a family member because we think it needs to stay within the family. But we all have siblings, and some of us have siblings who suck at math, and some of us have siblings who are great at math, and some of us have siblings who would be the best caregiver on the face of the earth if you got sick, and we have some siblings who will throw up if you cut yourself and they see blood, right? And so I think the first thing is, and it's really the only important decision you really have to make in this process is, who is my person going to be that I think can make good decisions? Or if they can't make a decision, they're smart enough to go out and hire a professional who can help them make that decision, right? Get an accountant, get a realtor, get a financial advisor, get a lawyer, someone who can help you make these decisions, right? So that's usually thing number one. Thing number two, and this is, again, where having a power of attorney document and a will makes things easier, is there's a ton of misinformation going around, which I think has gotten worse now that you can't really post news articles on Facebook anymore, because now people can post things on Facebook that look like news articles but really aren't.
Just like That Kingsville Podcast is not the news.
And we post articles like crazy.
All the articles.
Local entertainment.
Oh my gosh.
But it's similar. And the other thing I find too is especially because we're a border town, a lot of my clients consume a lot of American media. They consume American news radio, they consume American internet news or television news. And we do have different legal systems. They're similar, but very different, especially when it comes to estates. And we run into all this misinformation where a lot of, older people will say, well, I don't need a will because what I've done is I've put all my kids joint on all my bank accounts and joint on all my investments and joint on title to all the properties I own, which is great because when I pass away, it'll just roll over to them, right? And it's the most common misinformation that I see from my clients. And I will give each of you one guess as to why that's a terrible idea.
Because siblings fight.
That's one good one.
Yeah, because it's not the one.
No.
Ooh.
Yeah, I'm not gonna.
Government can still take taxes.
They could. So tax is a big concern. So the main issue is tax and shared ownership. So what people don't get is, if I put you joint on my bank account, Kevin, that means you now own my bank account as much as I own my bank account. So if you decide tomorrow you want to withdraw all the money out of our joint bank account, you can. I can't stop you. If it also turns out that you have a gambling problem or a drug problem, or you got sued or you went bankrupt, that's now an asset they can come after. Or as I just mentioned, more than half of marriages end in divorce. Any joint assets you hold as you go through a divorce are assets that your spouse can come after for an equalization payment. So the most common one is you've got mom and dad, they're both in their late 80s and they want to put their, 50, 60-year-old kids jointly on title to their, matrimonial home with them because they think it'll make things cheaper and easier. In a way it does, but it also means that if anything goes wrong with any of your kids, they're coming for that house. And that's the house you just spent the better part of the last 30, 40 years paying off and is probably your biggest investment going into your retirement years that you've now shared, either wittingly or unwittingly, with your children who have their own spouses, who have their own lives, who may make their own mistakes because none of us are perfect. So that's really one of the biggest ones I see. The other one from the tax perspective is this. We have tons of farmers and we have tons of business owners. If you put someone joint on that asset, then depending on what types of tax issues arise when you pass away, you're now dumping that in the lap of the person who is jointly on title. And you don't have that added buffer of it first going into your estate and giving us time to handle that tax issue inside of the estate. And the biggest one is, Most people who have a very modest, simple life, their only major asset they have is the house they live in and maybe the 1 or 2 cars they drive and whatever small, retirement they manage to save and their life insurance policy, which is fine. If we put kids joint on title to your principal residence, what do we, and I know it's tax season and everybody's sick of taxes. Steve, if I sell my principal residence today, if you sell your principal residence, do you have to pay capital gains tax?
I don't think so.
You don't think so. Exactly, because it's your principal residence. So the principal residence exemption says the house you live in as your principal residence is always tax-free when you sell it. Now, if you have a cottage property or commercial property or farmland or you own a condo building, if you sell that, that's capital gains taxable because it's a capital asset, right? So now, if we follow this bad logic that these boomers come up with through watching American shows, that we're going to put our adult kids jointly on title to our principal residence, mom and dad now die. Their names come off title. It now goes in the names of all of your adult children. If your adult children already own homes, it means they now own an additional residence, which means we've now lost all the benefit of the capital gains exemption. Because what happens 9 times out of 10, the kids want to sell the house. They don't want the house. We don't want mom and dad's house that they've lived in since 1972 and has all the floral print in the bathrooms and whatever. It goes on the market, it gets sold. The problem is it now goes on the market and gets sold, and there's potential that CRA is going to show up and ask questions and say, well, we know it was mom and dad's principal residence, so they don't have to pay tax, but you guys are all on title and you own an additional residence. So are we now going to pay capital gains tax or not, right? Whereas had we just left it in mom and dad's name, mom and dad die, we apply for probate, the executors get put on title because they're the executors, it's their job to deal with the property, and they sell it, it's tax-free. The estate pays no taxes because it is the principal residence, right? And it's the same issue in reverse when we deal with family farms. So grandpa has 500 acres of soybean fields that he bought in 1960 something for 3 nickels and a colored piece of glass because that's how cheap land was back then. It's now in prime greenhouse territory, which means that's worth between $25,000 and $40,000 an acre. That is a ginormous capital gain, right? And this is the other part of the estate planning as it applies to business owners and farmers, is if we don't start thinking now about how we're going to set up our estate planning, your estate is going to end up with a giant tax bill at the end of this because that is absolutely capital gains taxable. And if we don't have liquid assets to pay that, or if we can't borrow money, or if we haven't set up other mechanisms to ensure that there will be money there to pay for that when you die, then maybe your kids aren't going to get the family farm. Maybe the farm's going to have to be sold because that's the only way we can pay the tax man, right? And these are things where if we just leave it till the end, or if we just take what we think is the lazy way out of saying, well, I'm just going to add as many people jointly on these things as I can, it ends up causing more problems than it fixes. And that's kind of the issue with it.
Succession planning is one of those uncomfortable things, right? Like you never want to think about, I'm going to die and what's going to happen. But you hear about bad decision making or people taking advantage of those errors or those omissions or whatnot. In the greater scheme of things, like you've referenced a couple of things about businesses and farms. How does, a guy like me with a very modest family home and whatnot also have to consider in estate planning for protection?
I think the biggest thing for the average person to look at is ideally you'd like to have a little bit of life insurance. Life insurance is helpful because it's usually tax-free cash that you can use to pay for all sorts of expenses. Another great thing you can do early on is to prepay your funeral. And it's weird to walk into a funeral home in your 40s and say, I would like your finest pine box, please. And I would like, this music to be played.
Do you get to haggle with them like a used car?
You might. I know. The reason I say it, though, is it really does help at the end. And here's why. Typically what happens is almost all deaths are unexpected, aside from like hospice and palliative care deaths. Almost every death you go, oh, he was alive yesterday and today's dead. Most people aren't prepared. Now it's either your kid or your spouse who's going to have to deal with this. If you live a very long time, your spouse might be in her 80s or 90s. That's a lot of stress to deal with all of a sudden. And as anyone who has gone through this process can tell you, funerals aren't cheap. So if you die on Tuesday and you were doing fine on Monday, and now we got to pay between, $5 and $25,000, depending on how fancy we want our funeral to be, and we didn't budget for that, that's a big expense right off the hop, Whereas had you prepaid that 10, 15, 20 years ago, and you don't have to prepay the whole amount, there's all sorts of really interesting financing plans they offer you, then it's all taken care of. The other nice thing, and this is the other thing people don't understand as part of the services that funeral homes provide, the other annoying part of having to deal with the fact that someone's died, other than your grief of losing them, is so now I got to deal with this funeral. This funeral is expensive. I now have to call every government agency in Canada and cancel every form of identification or card they've ever had in the history of time. Nobody wants to do that. You want to sit on hold for 4 days with CRA to let them know that, Joe Blow has died? No. Then one of the nice things, again, about using a funeral home is they cancel all that stuff for you. They make sure your driver's license gets canceled. They make sure your health card gets canceled. They notify that your SIN number is no longer an active SIN number, all those fun things, right? And these are all services that mean that had you prepaid it, funeral director shows up and takes over. And it's really nice. And it's a completely stress-free experience because it's all been planned in advance. So any of your listeners or viewers that can afford to, I highly, highly, highly recommend, because it makes life easier. Because otherwise what ends up happening is someone's going to have to pay for this thing out of pocket, right? Because maybe grandpa lived to be 90 and didn't have a lot of money left in his bank account by the time he died. And now we got to pay for a $15,000 funeral,
and
right?
People don't understand. There is a death benefit that you do get from the government. But the death benefit, at least when I received it, was $2,500.
Yes.
Which covered very basic cremation.
Yeah.
With no vessel and no service and no nothing. So, with people that,
there's a death benefit. The government will pay for it.
it's such a falsehood.
No. And it's definitely, it doesn't keep up with inflation, and it doesn't keep up with the cost of what it actually is. And it leads to another point, which is, and I'm targeting this towards boomers because they tend to be most of the people I do estate planning for. But we also have lots of people in the Gen X and the millennial generation. But a lot of people now like to use the discount funeral providers, which is fine. But what they miss out on is it's usually an added charge for them to do the services of canceling everything and applying for the death benefit and doing that. And it really, really is valuable, because if you don't, it's a nightmare. Because I have clients that have done it on their own, and it's like a whole month of calling people and a whole month of sending stuff to places and waiting for various government agencies to process things and get back to you. And really, when you're grieving the loss of someone, do you want to waste your time doing that? You don't. And it's much easier if you just let a professional handle it for you, right? So that's kind of my school of thought on how you want to deal with these things in advance so that it doesn't end up being a giant problem down the road.
And identity theft is easier if there's no one to monitor anything, and if those things don't get handled properly, there's a high risk.
It's a huge problem. So and people are always like, oh, I don't want to tell the bank that that so-and-so's died because they're going to freeze the bank accounts. There's a reason why they freeze the bank accounts, because there are scam artists who spend their entire time searching Google for obituaries so that they can start applying for credit cards in the names of dead people. It is well known as an issue. It's the same issue while you're still alive. Why I strongly advise against putting people joint on bank accounts and things with you, because elder abuse is a legit problem. It's a huge problem. We have clients who've had their entire life savings wiped out because they thought grandkid so and so was going to be responsible with their money, and grandkid so and so wanted to clean out the bank account and invest it in Bitcoin, right? And those are not good decisions.
It's going up.
Yes.
Right? It was a sound investment.
It's a sound investment.
No,
I don't provide investment advice.
No, we're not the news.
It's the same. It's the same reason why I say the beautiful thing about a power of attorney is a power of attorney means someone is authorized to deal with your stuff, but it doesn't mean that that person owns your stuff. And it's a very important distinction, because it means that the bank monitors everything that person does. A bank doesn't monitor what a joint account holder does with you because it's their account. They don't care. So if they start withdrawing massive amounts of cash on a regular basis, as long as it doesn't tip off any money laundering things, they'll just let you keep doing it. Whereas if your power of attorney starts showing up at the bank every Tuesday and withdrawing $2,500 cash, at some point they're going to say, whoa, who are you giving that money to? Right.
When we've all heard stories of oh, I'm next to kin. I'm entitled to this. And then, they take whatever possessions that don't rightfully belong to them. And, that's the nightmare.
Yeah.
Right?
And it's why you want to have a lawyer involved in this process, because can you do everything yourself? Sure. I mean, you can change your own oil, and you can, arguably, if you watch enough YouTube videos, you could probably take out your own tonsils. It's a terrible idea. Can you do it? Sure. Would it be nicer if you had an expert who was a professional, who was not related to all the family members you're dealing with through this tragedy, handling this for you probably would be nicer, right? Yeah. And that's, again, where if you make these very simple decisions, if you have one 15-minute meeting with me at some point during the course of your life, 95% of these problems go away.
After the person comes to you, gets a will, it's not like there's a master registry of wills in the world. What do people need to do after they get the will?
That's actually a really good point. And a lot of people,
wills.
Yes, it would be helpful if we had one, to be honest. It's one of the biggest issues we have as lawyers in those jurisdictions in Canada where we do wills the way that we do them in Ontario. It's very true. There is no central database because it's a private document, right? I have solicitor-client privilege with you. I can't reveal to anyone that you've made a will with me, and I can't reveal to anyone where that will is or who's named in it until you die, and then only to the people named in the document. So it's why we need to get away from this old-timey way of thinking of like we never talk about money and we never talk about, big important life decisions. I'm not saying you have to shout it from the rooftops and go to the Legion and tell everyone you meet, how much money you're leaving to everybody. But if you make a will, please tell the people named in the will that they're named in your will, or at least tell your executor that they're your executor, and maybe tell your powers of attorney that they're your powers of attorney. But typically the process is the law office tends to usually keep the original will. So we have a fireproof vault in our basement where we keep all the wills, and we release to the client a photocopy of their signed will, and we release original copies of their power of attorney documents because they'll need those while they're alive. Because if there's an emergency, you're going to want that document when you go to the hospital, right? But yeah, it's a very good point because they do frequently go missing. And then the other most common, traditional way of handling things is in ye olden days, people would take their will and put them in their safety deposit box, which in theory makes sense until you understand the practical reality of how safety deposit boxes work. Do any of you have one?
No.
Well, no one here is over the age of 90. So,
but my mom also worked at the bank.
There you
advised against it for certain reasons.
And the reason is this. There's two main problems with safety deposit boxes. Three. One, you need a key. If you lose that key, that's a big problem.
It costs you a lot of money to get a replacement, and it's a long process.
Two, only the people who own that safety deposit box can enter that safety deposit box. So if you put your will in your safety deposit box and the safety deposit box is only in your name and you die, then how do we get into that safety deposit box to see if your will is in there? Problem. And then problem number three, and this is one that I never even knew until I had to deal with this. I had an estate file 4 years ago. A gentleman was a collector and he'd lived all over Ontario, and we found a safety deposit box key in his possessions. And luckily it had the logo of the bank on it, so we at least knew which bank we were dealing with. In a world where like Domino's Pizza texts me on Fridays because they know I tend to like to order pizza on Fridays and offers me, like they know more about my life than I do, you would think that the banks would have a central digital registry of safety deposit boxes. They do not, which I did not know. So you have to call and write to every individual branch of a bank that this person may have ever walked into in the course of their life to ask them if they have a safety deposit box on file for this person, which meant I think we sent like 36 letters to, and I can't remember which bank it was, but let's say it's RBC. So we pretty much had to retrace the steps of everywhere this man had lived over the course of his life and then see how many RBC branches we could possibly find in that radius, and then write to and call all of them to say, hey, do you have a safety deposit box in your branch registered to a John Smith? Because we need to get access to this thing. So they're a terrible idea for all of those reasons. I always say to people, like, if you really think it's important to keep it under lock and key, go to Staples and buy yourself a document safe and keep it in your house. Because if we can't get into it, at least we know physically where it is and we can get a locksmith to drill into the thing. But the bank isn't going to let me into the room if I'm not named on the thing. And that's always one of my big concerns about safety deposit boxes.
The other, and you mentioned it, but you glossed over it a little bit. And I do think that we need to dive into it a little bit more, is the idea of guardianship.
Yes.
Because I think most people would just automatically believe that if you're saying in your will that you want your kids to be in the care of these people, that would just be an automatic.
Yeah. And it ties into two really useful conversations. So the traditional guardianship in the sense of who's going to take care of my kids until they turn 18. So By law in the province of Ontario, if you die and you orphan your children, there are two main government offices that get involved. It is the Office of the Children's Lawyer and the Office of the Public Guardian and Trustee. The OPGT tends to deal with adults who are incapable, who are essentially wards of the state. And then the Office of the Children's Lawyer deals with children, and they usually work in concert with CAS. So when that happens, you can name someone in your will who you would like to have be the guardian of your children. But that doesn't mean that that person automatically becomes the guardian. What will happen is the Office of the Children's Lawyer schedules a court hearing in front of a family court judge, and that judge is going to decide who they want to appoint as the guardian. And it'll be done based on the advice of the Office of the Children's Lawyer, because they're going to vet that person. And then it'll be in the opinion of the judge, right? Because obviously, all of our life circumstances could change. So maybe you named your sister, and your sister was excellent at the point in life she was at when you made that document. But by the time you pass away, she's on her second bankruptcy and has been divorced twice. That might cause a situation where, the Office of the Children's Lawyer is going to say, we don't really think this person is suitable to be the guardian of this child, despite the fact that she's named in this will. And that, leads to the conversation about what happens next. The other interesting thing about guardianship is this. Frequently, people come to me and say, I want to leave stuff to my grandchildren or my great-grandchildren, depending on how long you've lived. What people need to remember is you are not considered an adult until you turn 18 in the province of Ontario, and you cannot own property until you turn 18. So sometimes they'll come in and say, I want to leave $10,000 to each of my grandkids. And I say, okay, how many grandkids do you have? Well, we have 8 grandkids. Great. How old is your youngest grandkid? Oh, like 2 months old. Okay, cool. So I always have to remind them, if you both die tomorrow, the money for that 2-month-old has to sit in trust until that kid turns 18, which means your estate can't be closed out, which means every year your estate has to file a tax return because it has assets. And those assets are an interest. It's got to pay an accountant. It's probably got to pay a lawyer for some legal fees. And that money's just going to sit there forever and ever and ever. We also see that mistake made with life insurance policies. So on life insurance policies, you can have a beneficiary designation, which is awesome. Sometimes people name minor children as the beneficiary of a life insurance policy. If you do that, you have to make it clear on the beneficiary designation form. You have to name someone who is going to be the guardian of that life insurance policy for that minor child. So I have a 5-year-old kid. I want to leave him $1 million life insurance policy. Great. Timmy gets the $5 million life insurance policy to be administered by his guardian. Name someone who's over the age of 18. If you don't, the insurance company will not pay that money out because they're not 18, which means that money gets paid into court, which means the accountant of the Superior Court of Justice in Ontario holds that money until that kid turns 18. So these are all things where, again, having a chat with a lawyer helps point out those, what you thought was a simple way of doing things might not actually work that way in practice, and why it's helpful to make sure that you have someone who's an expert in it look at it before you do it.
So, scenario, segueing slightly from that, let's say my parents or parent had a separate life, a separate marriage, a separate family. And I was a part of that first family, and he passes away, and there's a will, and I'm not named in it. And I feel that because of, the fact that he is my biological father, that I am entitled to some of this. Is there a mechanism, or is there something that people need to be aware of, how this occurs and what the precautions are?
So this is where we have...
Whoa. Kevin, hang on.
So you think he's got a will? He's not going to make it through the podcast. So I'm literally boring him to death. That's the problem.
What?
I'm good.
He killed one of the hosts of That Kingsville Podcast.
Did I go wrong hole?
Wrong hole.
Oh boy.
Yeah.
I hate it when that happens.
So to circle back, this is another one of those reasons why I say it's very important to make a will and to think about these things, because it is very common now that people might get married multiple times and might have multiple sets of children throughout those marriages. We call them blended families now. If you don't turn your mind to how are we going to arrange our affairs such that when we die, everyone in all of these families gets something, if that's what you want, or that we make it clear that we are cutting out certain people, because sometimes we decide we do want to cut certain people out. But if you just don't mention them, it opens up the door for that person to later challenge it in court and say, well, grandpa had dementia. He forgot I existed. That's why he didn't name me in the will. Right. And that's, again, where proper drafting is really important. And it's, again, why when people say, oh, well, it's okay if I don't make a will because it's all just going to go to my family anyway. I mean, it's absolutely the case that sometimes you become estranged from your children as you age, or you might have a child who doesn't want to have anything to do with you. If you don't make it clear that you don't want that child involved or you don't want that child receiving anything, then they're entitled to a share, right? And that's, again, where proper drafting makes life easier. We might not be the exciting courtroom lawyers, but we're the other side of the coin, which is, paperwork is boring and making grown-up decisions is boring and drafting things is extremely boring. But sometimes you need to hire that person who's good at drafting that stuff to make sure that that's in place for you.
What I'm trying to think how to phrase this question. Are there any other items? And I mean, we talked about kids and I don't want to talk about kids as an item, but in a will, they're kind of like an item. Mm-hmm. It's like, all right, here are things we need to deal with, right? Any other things that people may have that need to be dealt with specially? And one that just pops in my head would be if you're a gun collector.
Oh, yeah, for sure. So wills can deal with pretty much any type of asset on the face of the earth. So I think the main ones we want to look at is a business. So we'll deal with that at the end. And then, collectibles. So you have all sorts of things. Like you might have Bitcoin. You might have, maybe you were an artist or a designer of some kind, and you might own the intellectual property rights to a bunch of things that you've created over the course of your life. You may be entitled to royalties from something that you do if you're an artist of some kind. Or you're a collector. You have a gun collection, or you have classic cars that you've collected, or you have a whole bunch of Rolexes because you're into watches. My view is always, for the collector type of person, there's two ways we can deal with how we distribute your collection in the will. If it's a very valuable item, then I do want to specifically name it in your will and say, my Shelby Cobra Mustang will go to, Dave.
Oh,
well,
it's nice.
I also don't have a Shelby Cobra Mustang, so you get nothing. But
I don't have a radio, so you don't get that either.
Lies all around.
Do you still have CDs then?
I do have CDs. So we just don't have a medium upon which to play them. But point being, so my view is always, if it's something valuable or unique, I want it described in extreme detail in the will, and then I want to clearly indicate who's going to get it, right? Not just, my diamond necklace. If you have many diamond necklaces, that is of no help to anyone at all. But if it's, this specific diamond necklace with this colored gold of this carat weight, blah, 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 provides a little bit more description. Now, if it's more so we collected, but none of it is particularly valuable, but it might just have sentimental value, then what I usually suggest is I tell the person, go home tonight and write out a list by hand of all the things and all the people you'd like to have it and sign it and date it. And then what I do is I just add a clause into your will that says, if I leave behind a handwritten list of things that I want to give to certain people, it is my wish that my executors honor, the instructions in that list. But for valuable things, absolutely. And for really valuable things, I always say, make sure you get those things appraised also, because the biggest challenge, and circling back again to a horror story, I had an estate file where the gentleman died, had no will. Was a collector, was a coin collector, which was very popular in the 1930s through 1980s. So silver and gold coins and regular coins and old coins and stamps, and had dozens of giant Rubbermaid tote bins with binders itemized with hundreds and hundreds and hundreds and hundreds in the thousands of coins and stamps. And despite the fact that he had them all nicely put away in these sleeves, had never had them appraised. And the problem is, no one of our generation knows anything about coins and stamps, right? So now we had a problem. We have this collection that I could take to a pawn shop and someone would pay me the scrap metal value, but it's maybe we've got an ultra rare coin in there that's worth $10 million. I don't know. So it ended up that we had to continue renting this gentleman's retirement apartment because the collection was so big that we had to keep it somewhere and have the locks changed. And I had to hunt down a certified, I think it's called a numismatist, who is someone who is into coins and stamps. I think stamps are philatelists and coins are numismatists, which is, I learned random vocabulary because it was such a quirky collection.
The first time those words have been uttered in, a fortnight.
That's why we bill by the hour for fancy words like that. But and literally, I had to track down someone who was an expert in it. He was as old as the guy who had just died. And my biggest worry was that he was going to die while helping me with this estate file. And he would show up every day with his cane and he would sit down at a table that we'd set up and he would go through this collection and make notes. And it took him like a month, like 5 days a week, sitting there going through everything to sort all this stuff out. So long way of saying, and it turned out that there were 2 coins that were worth slightly more than their face value. But we didn't know, right? And so my thing is always, if you're a collector and you have something that is valuable, but that it isn't obvious that it's valuable, please get it appraised and please have an appraisal report somewhere so that your executor someday, when they show up and look through your stuff, say like, is it a knockoff Chinese Fender guitar? Or is it like, one of the Beatles held it briefly for 20 seconds in 1973? Like, okay, that's a totally different thing in terms of value proposition, right? So those are why, if we're collectors or same thing, if it's something that requires a license to have, like a gun or like a motorcycle or something weird, airplanes, who knows what you're collecting, boats, know where they are and know kind of what they're worth. So that again, when the time comes, it isn't, Dad had a hunt camp 7 hours north of Perry Sound. And if you look on the 3rd shed on the property, but not the 2nd shed on the property, and you look behind the 3 broken lawnmowers, there's, some ultra rare or something. Like, it'd be nice to know that in advance, right? The other thing with assets, the most important one is businesses, right? So what we offer at our firm is if you own shares in a corporation or if you have a business of some kind, our concern is, so a lot of small business owners and medium business owners, we use our businesses as our retirement savings vehicle, right? So rather than investing in an RSP because we don't earn T4 income, we accumulate corporate earnings in this corporation and we're going to use that over the course of our life to live off of. And if and when we die, we want the value of that to be distributed to our heirs. Great. Problem is, and this is again where misinformation freaks people out, I get phone calls that say, oh my God, I don't want my kids to have to pay inheritance tax. We have no inheritance tax. I will say again, we have no inheritance tax. We do, however, have to pay estate administration tax. So what that means is when I apply for probate, the court asks me to send them a list of the value of all of your assets, and they charge me a tax based on a sliding scale of the value of the assets. It is the lowest estate administration tax in North America is in the province of Ontario. It's like less than 1%, depending on where you slide in the sliding scale. Problem is, let's say you got your house and you got your car and you got, some modest money in your bank account. We'd pay estate administration tax on that. Now, let's say you have your and more store and you've accumulated a very large amount of money and investments in it. If we only make one will, then I've got to pay estate administration tax on the value of all of those assets. Or we could do the following. We could make you a regular will that says this will applies to all of my personal goods except for the shares I have in XYZ Corporation. And then we make you a second corporate will that says this will only deals with the shares that I hold in XYZ Corporation. Now, why do we do that? It's very simple. A corporation is a living, breathing entity. It has personhood, which means that just because the shareholder or the director or the officer of that corporation died doesn't mean the corporation died. It continues to exist. You don't realistically need probate to deal with those assets. So if we can ensure we set up your estate plan in such a way that we don't have to pay estate administration tax on the value of your corporation, then it's going to save your estate a whole pile of money going down the road. But again, that's absolutely an asset that you really want to think about in terms of, how to move forward.
So let's say I'm an avid, purveyor of the Jack Miner Society, and I really hate my kids because they suck and they were terrible in my old age, and I want to send everything that I have to Jack Miner, including like my house and my cars and whatnot. And Jack Miner's not going to be like, hey, I own 22 Regent Street or anything. Like, how does that happen? When that is the wishes of my...
Yep. So one of the wonderful things about estate planning is that you can do a lot of charitable giving. So maybe you didn't have any kids in life, or maybe your kids are all independently wealthy and they're already successful on their own, and you have a cause that you really want to support. So can we leave stuff to charities? Absolutely. My advice is always one of two things. One, make sure that you vet your charity very well in advance before we forever immortalize it in a will. Because if it turns out that it is not a very good charity, I can't really fix that once you're dead. Now, if it's, Dave's food and stuff charity that Dave convinced you one night at the Legion was absolutely a legit charity.
We got stuff.
Yeah, you don't want to leave stuff to
food and stuff.
We got stuff.
But whereas like UNICEF or United Way, they're not going anywhere. They're legit charities, right? So point being, absolutely make sure you do your due diligence on that in advance. It's also something we're happy to help you with at our law firm. We always do a lot of research, on our clients' behalfs. If they're like, either, we want you to look into this particular charity, or we have an idea of something we'd like to support. Can you help us find a charity that kind of meets those needs? That's thing one. Thing two, obviously, if you're planning on leaving everything to charity, this caveat doesn't really apply. But let's say, we're leaving the majority of everything to our kids, but we want to leave a percentage of stuff to a charity. Cool. The main thing you want to consider is, rather than leaving a percentage of everything you have to that charity, I always prefer that you leave a specified dollar amount. And there's a reason for this. So if the will says, I die and I want 50% to go to Dave and 50% to go to the Kingsville Food Bank. Great, that's fine. But the problem is this: if you leave a beneficiary a percentage amount rather than a specified dollar amount, it gives that beneficiary a right to force the executor to provide a detailed accounting of everything the estate had. Because if I'm left 50% of something, I have a right to know 50% of what. Now, if I leave 10 grand to the Kingsville Food Bank and the Kingsville Food Bank gets a check for 10 grand, Kingsville Food Bank can't ask any more questions because they got exactly what it said on the page, right? So it's always something I point out to people, especially really large charities. So, you look at, your Children's Hospital or UNICEF or your really, really big ones. You have to remember they have giant charitable giving divisions. Their job is to ensure they get every penny that's been left to them by somebody. So they will make your executor jump through hoops to prove exactly how much it is that they're being left if you leave a percentage. If you say $150,000 goes to UNICEF, UNICEF gets $150,000. Questions answered. So that's something to keep in mind on the charitable front. The other advantages for your estate, and it's usually something that your tax advisor can help you with. If you do have commercial properties or a business, and we're worried that there is going to be a giant capital gains tax bill at the end, a lot of charitable giving will help offset that by the tax refund, the tax credit that your estate will get as a result of that charitable gift. So there are also tax strategies for doing that as well.
Jeez. God,
it's all the information.
It is. It's a lot of information. So again, the event, Vern's May 6th.
May 6th.
5:30 to 7:30.
Yep. Or longer if people want to stick around and chat. We'll provide refreshments and food. It's all free of charge. What we'd love you to do is if you check out our Facebook page, there is an Eventbrite link, or you can go to Libro's website or Libro's Facebook page. I believe there's also an Eventbrite link there. Or you can RSVP by emailing me, sebastian@msslawyers.ca. It just helps us get an understanding of how much Johnny Bread Vern is going to have to make.
All of it.
How many bottles of 50?
How many bottles of that 50?
Over now.
I think the important thing, though, is we just want to make sure that everybody feels comfortable enough to come out and meet with us in person. There's no such thing as a stupid question. It's the kind of thing that nobody ever feels comfortable talking about, and we wanted to do it in an environment that would be more conducive to having a friendly chat like Vern's, which tends to be a good spot for that sort of thing. Mm-hmm. And hopefully we'll see people out there.
Yeah, exactly. It's a fantastic way to do some personal planning for the future that you don't consider. And if you aren't aware of what some of the intricacy is, you can get some insight and headway and plan for the future. So thanks for joining us on the podcast, Sebastian. And thanks everyone for watching and tuning in. Please like and subscribe, and we'll see you next time.